Ladies and gentlemen, put your hands together for Izak Venter.
Yes, thank you so much for being here today. It's wonderful to have such a big crowd with us today. And I am the first speaker because of a specific reason. I've got small kids at home, and when we have to give them medicine if they're sick, you just quickly grab the medicine, jam it in there, and then you must have the chocolate or the Coke or something ready to help them get it down. So today I'm going to be the medicine, and the next two speakers will be something a little more sweet. Today our purpose is to talk to you about deeds of sale. As conveyancers in the office, we frequently find deeds of sale that well-meaning agents have signed, which end up in our offices and which are completely worthless. They are literally not worth the paper it's written on. And of course we try and salvage what we can, but sometimes it's just not possible. So today we want to help you to avoid those pitfalls, and we're going to show you which are the common pitfalls that are out there that property professionals frequently fall into. And we're going to help you to avoid those, and we're also going to help you to know when this pitfall is coming and what to do. So the first part of our training today is going to be a little technical. We are actually going to read a clause in an act. So hold on, it will get better. First we're going to do the theory, and then afterwards the practical application. Also a few things are a little tongue-in-cheek to try and make it as light as possible. But let's start. Are you ready? Okay. Today we're going to talk about the magic of a valid deed of sale and the value of a valid deed of sale and what you can do with a valid deed of sale as opposed to something that's invalid. This is a motto from the US Army engineers. The difficult we do immediately, the impossible takes a little longer. And as conveyancers, that's frequently something that we're faced with. We sit with an invalid deed of sale, and a seller that urgently needs to sell, and a purchaser that knows he's got a way out here. And it is then expected of us to try and salvage this transaction. And as it says there, the impossible takes a little longer. Usually we are able to sort things out if you get people around a table and you convince and you discuss, and usually we can make a plan. But avoid those scenarios. Because who's going to be the embarrassed one when the attorney has to tell the seller, we've got a problem, the purchaser's attorney says the deed of sale is invalid because X, Y, and Z. That seller is going to pick up the phone and he's going to call you, the property professional. And there's nothing we can do. Of course, we try and explain, but there's nothing we can do to prevent that seller from being very unhappy with you, and you will lose a client right then and then. Not to mention that I think in future we're going to see sellers and maybe purchasers suing property professionals for damages suffered as a result of negligence. So you need to have the knowledge, you need to have the know-how of what to do when, and to see to it that when you conclude a deed of sale and you walk out there, that you actually walk out with something that's valid and binding and can be enforced in a court of law. Yes. And when she asked me to come down to fix it, I'm a lawyer, I'm not a magician. Okay, the birth of a deed of sale. We're quickly going to discuss today the life and death of a deed of sale. And as I said, initially we're going to do a little bit of the technical, the theory of deeds of sale and how they are created. So what are the legal requirements for a deed of sale to come into existence? It's very simple. In terms of our common law, the Roman Dutch law, it's consensus. But we also have certain acts that are available, and we're going to have a quick look at the Alienation of Land Act. Consensus is a meeting of the minds of contractants. A contract is created if the parties agree or reach consensus between themselves to create obligations or duties and rights. Very simple. You deal with that every day. You go back and forth between your clients to reach consensus about deeds of sale and prices and terms and conditions. How do we reach consensus? It's very simple. It's via offer and acceptance. That is a more than 2,000-year-old principle in our law. Consensus is reached after one makes an offer and the other one accepts it. One makes an invitation to consent to the creation of obligations, or usually an offer to purchase, and the other one would then give an affirmative response or an acceptance. Of course, an offer is only valid until it's either accepted, rejected, withdrawn, or when it lapses. Acceptance is a declaration of the will which indicates assent. This is not for your deeds of sale. This is for any sale transaction, for any contract, in fact. Acceptance is a declaration of will which indicates assent or consensus to the proposal contained in the offer. Anything more or less than an unqualified acceptance of the entire offer amounts to a counteroffer, and it constitutes a rejection of that offer. The formalities, and this is where we're quickly going to have a look at the Alienation of Land Act. Here we have, for any contract, that's buying and selling a car, for instance, or when you go buying something at game, it's offer and acceptance. But for the sale of immovable property, we have formalities that are required in an act, and it's called the Alienation of Land Act. And that is the most important piece of legislation that we've got from your point of view as a property professional. Unfortunately, it is very, very basic. It provides the following. Section 2.1 says, no alienation of land shall be of any force or effect unless it's contained in a deed of alienation, which is signed by the parties thereto or by their agents, and that's not an estate agent, that's somebody who's authorized to act on their behalf, on their written authority. So we've got two requirements for a valid deed of sale when it comes to immovable property. First of all, a deed of alienation, just writing. Something must be in writing, and it must be signed, either by the party itself, himself, him or herself, or by somebody acting with their written authority. That's all. That's all the Act says the requirements are for a valid and binding deed of sale. Question: does it require witnesses? Are deeds of sale without witnesses valid? Yes. The Act does not require witnesses. Does it require for every page to be initialed? Nope. No such requirement. Does it require that all changes and amendments be initialed or signed by witnesses? And nope, it's not there. Which means that if you have a deed of sale, 10 pages long, with all the relevant provisions in it, but it's not, none of those pages are initialed or signed or anything. It's only signed at the end thereof by the parties. Do I have a valid deed of sale? Yes, I do. The problem with that is that we will frequently, with that kind of an agreement, have a problem as to exactly what the agreement was. Was that first page the right first page? Or was it the page that says the purchase price is 1.6 million, whereas the one that was handed over to us says 1.5 million? The reason why we have those initials and those signatures and those witnesses are for proof in court to show what the agreement really was. Unfortunately, it doesn't invalidate the agreement if those witnesses did not sign. As an attorney, I would have preferred for that deed of sale to be invalid. Why? Because an invalid deed of sale just means that my seller must sell to somebody else. It may take a month, it may take 6. But if we have a problem in knowing what the terms and conditions of that deed of sale is because the pages or the amendments were not initialed, that creates a problem. That means that parties are going to run to court and try and enforce what they believe the terms and conditions of that deed of sale is, which can keep my client in court for years to come. So the problem is that it doesn't require witness initials. And that's why we ask you, please, 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 just because the Act says you don't need it, does not mean it's not necessary. It's absolutely essential to have it, but it's not essential for a valid and binding deed of sale. Everybody with me on that point? Okay. We've dealt with the two requirements, a deed of sale and signature by all the parties. The result of non-compliance, if you don't comply with that, is that it's of no force or effect. So if you had something that's not written in your deed of sale, something that was agreed to verbally, but it's not stated in your deed of sale, and what you're selling is immovable property, then you have a problem. Because that other agreement is of no force or effect. And if the purchaser calls and he says, I'm not going to get my bond today, and today is the last day, and the seller says, it's okay, you can get a postponement. It's not reduced to writing. What is that agreement? It is of no force or effect. It's a nullity. It doesn't exist. It's literally, your deed of sale will not be worth the paper it's written on after that due date for the bond approval. Okay, everybody with me? That's why it's so important to us, and I hope we can convey the message today that when it comes to deeds of sale, you need to cross your T's and dot your I's. It is an exact science. Just a little late is still late. It's still out of time. Okay, what if a property is still transferred despite the fact that maybe there was, the bond was approved a little too late? Luckily, the Alienation of Land Act helps us there. It says it is regarded as valid ab initio, meaning from the start, if the purchaser performed and transfer has taken place. So the purchaser has paid his deposit, he's proceeded with the bond, and transfer has taken place. Then luckily for us, the Alienation of Land Act says that deed of sale, which was invalid, which has lapsed, is now regarded as being valid from the start. Okay, now we're going to get to the practicalities. That was the theory, and we're going to try and apply it now. There are various ways in which a deed of sale can pass away. It can die. We literally have, I've seen deeds of sale die on my desk in front of me, and there was nothing I can do about it. Wish I had a medical degree. Okay, we're going to look at the death of a deed of sale. First of all, stillborn deeds of sale. In other words, deeds of sale that were never born, that never came into effect. And then we're going to look at dreaded diseases. So we have a deed of sale that came into existence, but it is terminally sick. There's a problem. We need to medicate it somehow. Deeds of sale that never came into existence, the following reasons usually apply. An offer which was not accepted in time. Or a counter offer that was made and then not accepted. The incorrect parties are used. So the husband and wife thought the property was in her husband's name. They married out of community of property use. He signs a deed of sale. Afterwards you find out it's in the wife's name. Is that deed of sale valid? No, unless he had the written authority to act on behalf of that wife before the deed of sale was signed, and of course if his name her name was stated in it. So the incorrect parties also causes for deeds of sale to be invalid. And while I'm on that point, I know we've said this before. It is for the exact same reason as the Alienation of Land Act, which we say trustees, when they sign an offer to purchase or a deed of sale as purchaser or seller, the trustee that signs need to have had the authorization of the other trustees when he signs that deed of sale. I think about 90% of us know that, but for the other few, please do not sign deeds of sale in which a trustee signs on behalf of the trust if you don't know who the other trustees are and you don't see something in writing that authorizes this trustee to sign on behalf of the others. A resolution or a power of attorney, or the third option is just to have every trustee sign. Okay. Deeds of sale that were validly, that was stillborn, but now we're quickly going to have a look at dreaded diseases, because that is what we deal with most in the office. Those are deeds of sale that were validly entered into and were valid and binding, but they are now in danger due to suspensive conditions, breach by a party. Sorry, this or repudiation by one of the parties, and I'll explain repudiation to you just now. We're going to have a look at each of these. Or lastly, parties wanting to cancel. As soon as one of these four are present, then you have a dreaded disease of your deed of sale. Your commission may not be paid because this transaction maybe will not register. Let's have a quick look at the suspensive conditions. Oh, and what happens if your deed of sale passes away? We're going to have a little solemn moment, and you're going to have a tear, and your commission is absolutely gone. Bond conditions. Bond conditions, as I said, are an exact science. If that bond condition says that I have to get a bond in the amount of 1 million rand by 4 o'clock today, then a bond at 10 minutes past 4 is too late. And if the bond is for 990,000 rand and not for 1 million, it is too little. That bond condition was not complied with. Yes, the purchaser can decide to accept that, but you will need to sign something to say, I accept this offer that was made, if it was made before the time, and I am going to proceed with the deed of sale despite the 10,000 rands deficiency. If it was too late, the parties need to sign an addendum before 4 o'clock to agree to an extension of time. If that agreement was signed after 4 o'clock, you have a dead deed of sale. And I can't emphasize this too much. And what we frequently see, and agents do this very well, meaning they go and send out the addendum, but the seller unfortunately is not available tonight. So he's going to sign it tomorrow morning, but he's going to date it for yesterday. People, that is so dangerous. Because most of your deeds of sale and addendums are nowadays sent by email. So it's very easy to see when that thing was scanned and signed and sent back. And if your purchaser wants to get out of this deed of sale 2 months later because he's now discovered the crack behind the curtain, it's going to be very easy. He's going to run to an attorney who's going to call for that addendum, and they're going to find out it was only signed the next morning. And what am I going to do to protect you? There's absolutely nothing we can do. So please avoid that embarrassment. Oh yes, and while we're on bonds, when it comes to standard terms and conditions, most of your deeds of sale will say that a bond needs to be approved on the standard terms and conditions of the bank. That excludes subject to valuation. If it says subject to valuation, it's not a final bond approval. It is not a standard term or condition. And if it states that it's subject to the cancellation of another bond, in other words, a property that your client already owns, which maybe is got on the market, it is also still not a bond approval on the bank's standard terms and conditions. So that would not suffice as a bond approval. Okay. Sale of a property, there are of course various forms of this suspensive condition in your deed of sale. It can be sold or sold and transferred. I, the purchaser, include a suspensive condition that I want my property to be sold. This transfer will only proceed once I've been able to sell my property, and some of them say sold and transferred. And when it comes to sold and transferred, be very, very careful about the time given there. Think practically. It takes a conveyancer between 6 to 8 weeks to pass transfer of a property, but that is after the suspensive conditions have been complied. So if you have a self-employed purchaser, you know your bond approval is going to take longer than usual. Then don't include their sold and transferred within 2 months. He may get it sold, but he's not going to get it transferred in 2 months. Do you agree with me? 72-hour clauses, of course, is another one, a suspensive condition that we see a lot of nowadays. I don't know why. I think it's because of stock issues. Am I right? 72 hours and backup clauses, and be very, very careful when it comes to 72-hour clauses. It must be done absolutely correctly. The notice to the first purchaser, please call us. If you've got a problem with that, we'll gladly assist. And yes, in our office, if we get in a 72-hour notice, it is battle stations. We do that immediately. but it is something that can go very, very wrong. Okay, breach. That's the other problem that we have. The other dreaded disease is your purchaser said he's buying it cash. He's going to put down a deposit of 100,000 Rand within 24 hours and the balance, the other 900,000 in 2 weeks. And then we have a problem. We call him and we say, where's that deposit? And he says, oh, no, but I told the agent it is in an investment. I need to give 30-day notice. And the problem is that, although technically speaking, he can provide us with proof that he's got it, but it's still not a deposit. And if we tell the seller that your purchaser still not paid his deposit, he can say, but put him to terms. He's got 7 days to pay that, or otherwise I cancel. Somebody else knocked on my door last night, not through the agent. They came to me directly, and they're offering me 200,000 Rand more. And then you sit with a problem just because maybe you didn't ask your purchaser where's his deposit coming from. So if there is breach, we need to investigate quickly and see what happens. Because let me just quickly explain, because I know there are experts and novices here. Breach is when one of the parties to a deed of sale breaches one of the terms, one of its obligations in terms of that deed of sale, thereby enabling the other party, usually the seller, to give the first party notice in terms of your breach clause. And the notice usually says the notice period is 7 days. It says, after 7 days, if I've given you notice and you've not paid your deposit, you've got 7 days to pay. If you don't, I will have the right to cancel this deed of sale or enforce this deed of sale. Usually the option that the sellers follow is cancellation. And then, of course, with cancellation, what happens to your commission? It's gone. Yes, we've spoken about the cash transactions and then occupation issues. Those we've had, last month we had 6 transfers delayed because tenants were in the property and the sellers thought that they are moving out. Always call for the lease. If you have a mandate to sell a property and there's a tenant inside, please get a copy of that lease. And even if you have a copy and you see, but this term is at the end, or this lease is at the end of its term, ask the tenant, are you moving out? It's not a guarantee, but you'll get a very good indication of whether that tenant is going to move out or not. It's a disease that we suddenly sit with. Tenants just refusing to move out. As I said, 6 transactions last month, not only delayed, some are in risk of cancelling, because what happens is that the sellers forget that there's a right of extension in that lease. So the tenant says, but I've elected to stay on for another year. And if that is true, then there's absolutely nothing we can do. Yes, and then deposits and guarantees, please make very sure about the timing. When you complete your deed of sale, ask your purchaser. I know in South Africa we are too embarrassed to ask about finances. But ask your purchaser. You say you've got the deposit. Where? How soon can you access it? Is it immediately available? And the balance purchase price, where is it coming from? Oh, it's coming from overseas. What's it coming from? Is it an investment you've got overseas? Start asking those questions so that you can identify the problems that you may have in future. It's all about managing expectations. If your seller knows there may be a delay in getting the balance purchase price, if he knows before when he signs, he's going to handle it much better than if you have to notify him that there's a delay 2 weeks before transfer is supposed to close. And this is the first time that he's heard it. So be careful of that. Repudiation. I'm quickly going to explain repudiation because I find most agents don't know what repudiation is. If one of the parties to a deed of sale suddenly decides, I'm not proceeding, he just says, you can do what you want, I'm not proceeding. That is what we call an act of repudiation. He denies being liable to proceed with the transaction. In a case like that, what does the seller need to do? Must he then put him to terms? In terms of the breach clause? No, he doesn't need to. He can simply write a letter and say, I accept your repudiation, the deed of sale is hereby cancelled. And I'm retaining your deposit as damages. It can be done. So it's very, very dangerous for any party, be it the purchaser, be it the seller, to just suddenly say, I'm not proceeding with the deed of sale, I don't regard it as valid. It's an act of repudiation. A breach notice is not necessary. The transaction is simply cancelled by the other party, and if there's a deposit at play, it would be at risk. So be very careful of that. This is a few we've had recently. One said, I'll repeat it in English. Neem asseblief hiermee kennis dat ek my offer op die erf onttrek. Hereby take notice that I withdraw my offer on the property. People always think that the deed of sale they signed is an offer and that they can just withdraw it. It's not. If that deed of sale was accepted, it is a contract. It's valid and binding. And then this guy wants his deposit back. The next one says, I can't wait forever. Transfer can't take place. I'm not interested anymore. Those are examples of repudiation. That means the other party can just say, okay, I accept it. Goodbye. As easy as that. As quickly as that. Before you as a property professional is even aware of the problem, poof, the whole deed of sale is gone. So be careful. Then cancellation agreements are the next one. If consensus is reached by parties who wish to cancel to a deed of sale, then of course they can sign, it needs to be signed, a valid deed of cancellation. That can be done very quickly as long as it's in writing and signed, the transaction is cancelled. A cancellation agreement can also provide for damages. We deal with this quite frequently in the office. We frequently get requests from both buyer and seller on the same transaction that they want to cancel. Of course, they can't just cancel and not pay the agent's commission, so we can provide for damages or for commission to be paid out of deposits. And this is an example of a cancellation agreement. It just says, whereas an agreement of sale was entered into by the parties on a certain date, and they now wish to cancel. Now, therefore, they agree as follows. 1, that a deed of sale is hereby cancelled by agreement. 2, that there shall be no consideration payable for the cancellation. And 3, in this case, there shall be no commission claims against either purchaser or seller. In this specific case, the agent made a big mistake. And that's why this agent said, I'm not going to claim commission. They forfeited their right to claim commission. Okay, but we see these quite frequently. And what happens to your deed of sale if that one clause is not complied with? You see that little line. You still thought you had a deed of sale. It's still there in your diary. My commission must pay out on this date or this date. And suddenly, before you know it, it's gone. It's gone. So we need to attend to our deeds of sale very quickly. As soon as we find out that there's a problem, my purchaser is in breach, or we're getting close to the bond due by date, or they are fighting about that crack behind the curtain, and the purchaser has just repudiated the agreement. I know another purchaser is knocking on the door. That's something that we must address immediately if we want to get our commission. Then, which medicine do we prescribe for which dreaded disease? If it wasn't validly accepted, if your deed of sale never came into existence, you must re-sign a fresh deed of sale. If that offer said it's valid until 4 o'clock this afternoon and it was signed 4:15 people, it is invalid. You can't. Even if the seller, when he signs at 4:45, goes back and he changes the valid by date, he just extends it by a day, and you send it back to the purchaser, and he also initials next to it, it's invalid. Because 4 o'clock this afternoon, when that deed of sale was not yet accepted, that deed of sale passed away. It's gone. You can play the last tattoo. It's gone. If the seller accepts a dead deed of sale, it is still dead. It doesn't change the fact that it's dead. He's just signed a dead deed of sale. And the fact that the purchaser accepted an initial next to that alteration extending the date, if he extended it afterwards, it still doesn't make a difference. It is still a dead deed of sale. But we'll help you just now. So when it's not validly accepted, you need to sign a fresh or a new deed of sale. They can't accept that same one. You need to complete a new one with a new date and fresh signatures on it. If a condition was not fulfilled, then before the condition is not fulfilled, you need to waive, your purchaser needs to either waive that condition if he's prepared to, or maybe just the portion that's lower than the amount of bond gotten, or you need to extend your dates. But all of that needs to happen before the date mentioned in your deed of sale. I know you think, oh, this is obvious, but you won't believe how many times we see it, because that temptation is just too strong. when a seller says, but I'm not available, I will sign it this evening and fax it through or scan it through immediately. It's fine if they want to do that, but then get them to sign a new deed of sale. Because otherwise you are at risk, and we deal with the fallout from those risks every day. Breach, of course, you then need to either convince the party to perform or discuss and amend. If your purchaser is unhappy about the plans of the property or something, and he refuses to pay the balance purchase price, maybe you can negotiate to have it amended. If it's repudiation, you need to negotiate with the party who wants to repudiate before the other one accepts it, and amend your deed of sale if possible, if it's a matter of the purchaser being unhappy with something in the deed of sale provision. And if it was cancelled by agreement, if that cancellation agreement was signed, can they just revoke that cancellation agreement and then proceed with the deed of sale? No, they cannot. As soon as they signed it, the deed of sale passed away. The last tattoo played, and your deed of sale is gone. You cannot proceed on that deed of sale. This is an example of an election or a waiver. This is where a purchaser got, and we'll send you these notes as well, so you'll have them for you to use. And I'm going to unfortunately read it to you so that you can understand what I'm talking about. Regarding the deed of sale signed between purchaser and seller on a date in respect of a specific property, the purchaser hereby confirms his election to accept the reduced bond granted in the amount of, and in the amount that was granted by the bank, and hereby waives the benefits. In other words, hy doen afstand. Hy sê ek vereis nie meer daai volle verband nie. I waive the benefit of the provision of the suspensive condition as in contained clause whatever in the deed of sale signed on this date, insofar as it relates to the deficit in the amount of the bond obtained. So he still retains his bond clause. The bond clause is still there. It's just the amount that was reduced. Why is that important? Do you know? What happens if he waives the entire bond, and suddenly a week before transfer the bank recalls or NTUs that bond? This way your purchaser will still have the protection of the bond clause insofar as it relates to the amount not waived. All right. Then the second paragraph, the purchaser hereby confirms that he will provide the conveyances with bank guarantees for the payment of the balance. So he wanted a 100% bond. He got a 90% bond. He waives the 10%. But what about the other 10%? We need to know what's going to happen with that. He will provide the conveyances with guarantees for payment of the balance of the purchase price, or alternatively, pay the balance purchase price into the trust account within 14 days. Do you understand why that's necessary? Good. The big difference, when deciding on a cure, it's very important that you need to distinguish between a deed of sale which is still valid and one which is already passed away. A deed of sale which is still valid, you've still got something that you can give medicine to, you can still try and keep it alive. Once it's dead, you cannot resuscitate it, it's gone. You cannot revive the dead. We have no zombie contracts aren't regarded as valid in South African law. And I know it sounds very, very obvious, but as I said before, we see it frequently from good agents, well-meaning. It's just because that seller said he'll sign it that evening. He couldn't sign it any other way. That's okay, I know he couldn't, but what should be done is a new deed of sale should be signed, because this one is dead. It's gone. So how do you revive a deed of sale? The answer is you don't. You sign a new one. But today we've got a little bit of magic for you. We are going to help you, and that's the whole purpose of this talk. Rather than tell this seller, it's okay to sign it tonight at 8 o'clock, even though it lapsed at 4 o'clock. We are going to help you. There's something else we can do. There is a new agreement of sale, and let's have a quick look at it. You'll see it's a one-page document. It just refers to buyer, seller, and the agent in respect of this property, also known as and then the street address, whereas the agreement of sale was entered into between the parties on a certain date, and whereas such deed of sale lapsed or did not come into existence or effect due to, and then you can just write in there, not being accepted in time, or the bond not being granted timeously. Now, therefore, the parties agree as follows, that the seller hereby sells, and that the purchaser hereby purchases, it's a new deed of sale, the above-mentioned property on the same terms and conditions as those contained in the deed of sale referred to above, but for the fact that the following dates are hereby extended. And then you can extend your bond due by date. You can change your date for acceptance of the offer, or whatever is necessary. That one-page document is what's going to help you in that situation. Do you need to attach your old deed of sale? You can if you want to, but it's not necessary. As long as that deed of sale can be identified by the parties and the date on which it was signed, it's not necessary to attach it. You can send this one-pager off to your purchaser to sign it and your seller to sign it. Do you agree that's much easier than just trying to convince that seller to scan and send it the next morning? Won't that reduce your stress levels and make it much better? I understand. It's your seller. You can't force him to sign. If he's taking his wife on a romantic date tonight, he doesn't want to be bothered with signing deeds of sale in time. And you don't want to force them. But please, if you don't force him, at least get him to sign the correct documentation. Do you agree that this is going to help you? We use this in the office a lot. As I said, you'll get a copy at the door and we'll forward it to you as well. Okay, the consists of a valid agreement. If you had that thing signed, instead of that document that was signed too late, the legal term is pacta sunt servanda, and it's one of my favorite legal terms. If a purchaser calls me and he says, I don't want to proceed with this deed of sale anymore, I tell him, pacta sunt servanda, and they always think I'm swearing. I'm not. It means agreements must be honored. If you sign something, you must honor that agreement. You must stick to your commitment. Otherwise, there's legal consequences. That deed of sale, that one-page document is enforceable. You can take it to court. You can force that purchaser to proceed. If he doesn't want to sign, I can get the sheriff of the court to sign my transfer documents. And I can pass transfer without your purchaser even signing transfer documents. Because pacta sunt servanda. It's like magic. The transfer can pass even though it's not signed. A correctly completed and signed deed of sale is powerful and capable of enforcement in a court of law.